It is 9:03 on Wednesday, April the 3rd. The House Criminal Justice Subcommittee is now in session. Madam Clerk, take the roll.
Representatives Davis, Fritz, Gillespie, Hardaway, Howell, Halsey, Johnson, Lamberth, Moody, Russell, Towns, Chairman Doggett.
Present.
Chairman Doggett, you have a quorum.
Thank you, ma'am. Members, do we have any personal orders before we begin? Seeing none, we'll go to our Sergeant of Arms, Mr. Tyler Muniz, for our final weekly words of wisdom.
Chairman, today's weekly words of wisdom come to you from a long-serving member who has stepped out of the committee, but I will proceed as slowly as I can in hopes that he will come in just in time to hear his words. The Memphis of Mayhem, serving the 84th District, Representative Joe Towns. That sounds like Mo, Larry, and Curly stuff to me. Y'all have a great day.
Thank you. All right, members. We're ready to rock and roll. We've got a lengthy calendar. I'm going to recognize Representative Johnson on item number 1, House Bill 2606.
That bill was killed in the Senate, so I am taking it off notice.
All right. Thank you, ma'am. I'll recognize now Representative Mitchell. He's got a couple bills here. He's going to...
Yeah. Hey, thank you, Mr. Chairman. I appreciate your indulgence, okay. As well as the Senate. Previous Representative Johnson's bills. Mine were killed in the Senate, but we still have a job to do, committee. Just because the Senate has killed these bills, I've given you a publication to look through, and you can see what assault rifles and guns do to our children in schools. It's our job to do something. It's not fun. We got two different competing sides in this state, but it's our job to do something. And the next time, there's a school shooting, we got to ask ourselves, could we have done something? So with that being said, I appreciate y'all, but we got to work together and solve this problem. Thank y'all.
Yes, what we'll do is at the end, we'll take everything that's off notice that has not come to fruition in the Senate. We'll dispose of them at the end of the calendar. Item number 6, House Bill 1600 by Representative Williams. You are recognized. There are 2 amendments. Which one do you wish to proceed with, or a combination thereof?
Thank you, Chairman and members. The amendment that I'd like to attach to the bill is 015098.
All right, you're recognized on the amendment.
Thank you, members. This bill, as amended, was brought to me by my local district attorney's office in regards to an event that occurred in Speaker Sexton's district. There were 2 juveniles who had created a plan to shoot up 2 schools in his district. The parents found the plans and notified the other juvenile who was going to participate in this planned event, and notified the parents that their sons had determined to do this. The parents got together and said, wait, I'm going to gather my son. They went to the sheriff's office and turned their sons in. Consequently, those 2 juveniles were adjudicated delinquent of their crimes, the eldest of which now is 18. Under current statute, those individuals, because of their court cases being preserved or sealed, those juveniles, even though they had a plan to shoot up a school, have the ability to buy a long gun at 18 and a handgun at 21. What this bill would simply do is it would create the ability for, if a juvenile is adjudicated delinquent of a crime in which that handgun or a knife, an aggravated assault, aggravated rape of someone occurred as a juvenile, what it would do, it would allow the clerk's office within 3 days of that adjudication of that crime to notify the TICS system at the TBI of that offense, and it would prohibit any juvenile who committed those crimes from being able to buy a gun before their 25th birthday. The reason for the 25th birthday is because in the medical community, as well as in my own personal life, I'm not sure my frontal lobe was fully developed until I was well after 25. But what this would do, it would allow us to be able to delay that. It would not take away the right, anyone's Second Amendment right, but it would allow them to delay that for a short period of time until after the juvenile has been released from their the penalty of their juvenile crimes. The bill also. Let me clarify, however, in no way, shape, form, or fashion would a juvenile's records be or case files be released as it relates to the tenets of this bill. Those would still be preserved. It's simply just a notification to the TICS database as it relates to TBI. With that, Chairman and members, I'm happy to answer any questions the members might have.
All right, any questions on the amendment, Leader Lamberth? First.
Previous question on the amendment.
All right, question's been called on the amendment. Objection? All right, there's objection. All right, we're voting on previous question. Those in favor say aye.
Aye.
Those opposed? The ayes prevail. We are on the bill as amended. We adopt 15098 on the House Bill 1600. Leader Lamberth.
Move previous question.
Question's been called. Objection?
I have a serious question that quick that needs to be asked. Why can I not find out something about this bill? Do y'all want to hide the fact that it might take a while?
Hey, look, we're in the middle of a committee here. You and I have been down there a long time. This isn't appropriate.
Well, this is,
I've had a motion. You can.
All right, there was objection. We're voting on previous question on House 1600, House Bill 1600 as amended. All those in favor of previous question say aye.
Aye.
Those opposed? No. Previous question prevails. We're now voting to send House Bill 1600 as amended to full criminal. All those in favor say aye. Aye. Those opposed? No. The ayes prevail. You move forward. If you wish to be recorded as a no, please see the clerk.
Thank you, Chairman and members.
Item number 13, House Bill 1881 by Representative Capley. We're on item 13. All right. You're recognized.
Thank you, Mr. Chairman. House Bill 1881 creates a Class C felony for assault on a police officer. Moves it from a Class A misdemeanor to a Class C felony, and that's the bill.
Okay. Any questions for the member on the bill? All right. Members, we're going to take a 1-minute recess. All right, members, we're back in session. We're on House Bill 1881 by Representative Capley. It is properly before us. You are recognized.
Thank you, Mr. Chairman. This piece of legislation makes assault on a police officer a Class C felony.
All right, any questions for the sponsor on the bill? Seeing none, we're voting to send House Bill 1881 to full criminal. All those in favor say aye.
Aye.
Those opposed? The ayes prevail. If you wish to be recorded as clerk, as a no, please see the clerk.
Thank you, Mr. Chair and committee.
Thank you. That was 13. Item number 12, House Bill 1128 by Representative Gant. You recognize there are 3 amendments. I'll give you a second. All right. This is number 12.
Thank you, Mr. Chairman. The amendment is 17593.
Amendment Code 17593. You're recognized on the amendment.
It makes the bill. If we can put it on and then talk about the bill as we go forward, or I can
All
talk
right.
about it now.
Without objection, we're voting to add Amendment Code 17593 on the House Bill 1128. All those in favor say aye. Those opposed? The ayes prevail. You adopt on House Bill 1128 as amended.
Thank you, Mr. Chairman and committee. What this legislation does is the purpose of this bill is to provide data that will ensure the Attorney General has standing to bring suit against the federal government if he deems necessary. And all this bill does is 3 things. It requires the arresting law enforcement agency to collaborate to verify citizenship when a person is arrested in the state. It requires the jail to report persons who are not lawfully present, and it defines not lawfully present within the United States. That's it.
Any questions for the sponsor? Seeing none, we're voting to send House Bill 1128 as amended to full criminal. All those in favor say aye.
Aye.
Those opposed? The ayes prevail. You move forward.
Thank you, Chairman and committee.
Okay. All right, we're going to skip around just a little bit to accommodate folks that are in other committees and not here. Let's go to item number 28, which is House Bill 1720 by Vice Chairman Gillespie.
Motion.
Got a motion? Got a second? Vice Chairman, you're recognized on House Bill 1720.
Thank you so much, Mr. Chairman and committee. This is a pretty simple bill. What it does is it increases the possession or knowingly possessing or stealing a firearm that's stolen from a Class E and Class D to a Class C felony. Right now, the way guns are handled, at least the theft of guns, or they're based off the dollar amount of what the firearm is worth. This just simply increases the felony across the board. I think most people would agree that a gun that's worth $50 is just as dangerous as a gun that's worth $100 or $1,000 for that matter. And with that, I welcome any questions.
All right, questions for the sponsor? Peter Lambert.
If we go out of session just for a moment, I've got a quick question for legal.
All right, without objection, we're going out of session. Legal, here's
right.
your question.
So when determining whether or not a gun is stolen, I've always at least thought that there were some criteria on the determination for someone to know that the gun they possess is stolen. There obviously, it's possible for someone to purchase a gun either from a store or an individual and not actually know. So what are the criteria in the statutes, if you know, for determining that?
I think they would have to know that it was stolen, so they would have to know. I mean, I don't.
And specifically, and we may be able to come back after some debate. By the way, for those that are watching, the lawyers that work for the legislature, in my humble opinion, have the most difficult jobs of any lawyers in the state. They are asked questions on the spot of everything in that entire code over there and expected to be able to pull up at their fingertips. So thank you for the job you do. But I've always, and maybe this is case law, that there was some sort of a time frame, 24 hours after something was stolen, there was a presumption that if you're in possession of stolen property or a stolen weapon within a certain time frame after it's stolen, then there's some weight given to that. But I don't know if that's something that's more kind of been derived out of case law and practice, or if it's something that's statutory, and I did not look that up before today's time. So that's my question.
Under 3914, Michelle Fogarty, Legal Services. Under 3914-107, it's an affirmative defense to theft of property if the person acted under an honest claim of right to the property, or they acted in an honest belief that they had the right to obtain or exercise control over the property, or they obtained or exercised control over it honestly believing that the owner, if present, would have consented to it.
Okay,
them
thank you.
having it.
All right, thank you very much.
Representative Towns.
Look, Mr. Chairman, thank you. Along the same lines, let's say it's legal that someone goes to a swap meet or one of these gun and knife shows. Somebody's there, not people that are hosting the show, but you have people that are congregating there. They buy a firearm there, and it's stolen. Don't know, but it is stolen. So how does the law impact that? And that happens across the state, across this country every day in some area.
Michelle Fogarty, Legal Services. I think the same defenses that I just read could also be raised in that occasion. If they purchased it, gave money for it, then that would certainly aid in their defense. But that would be fact dependent, and for the jury to decide whether or not they actually knew that it was stolen. Those are questions of fact for the jury.
Thank you, Mr. Chairman. Thank you, legal.
Following up on the leader's question, there still is a valid charge of possession of stolen property with an assumption that you know that you knew it. I mean,
Yes, sir.
okay. Any other questions for legal? Representative Towns, go ahead.
This is for you, Mr. Chairman. So, okay, being an officer, former officer, you're saying it's still a valid charge. It's a charge that's on the books as already stated. So that circumstance does not necessarily help the person, or it's up to the judge to determine.
At the end of the day, yes, the jury or the judge is going to have to determine, but I've used the charge many times.
Mm-hmm. Okay. All right. Thank you, Mr. Chairman.
Any other question for legal? All right, we're back in in session. Well, see, you start talking police work, and here we go back. It's at 10:08. All right. To the sponsor of the bill, you are exactly right. Everything in code is set up on amount theft-wise of how much you stole. I really do have a problem of isolating. I know what you're trying to fix, but isolating one thing out of an existing code and saying we're not going to use a monetary value for that. If you steal $10,500 in a burglary, you're going to be charged with the burglary, but we're going to isolate this $400 handgun out and make it a Class C felony. I have problems with that. I just want you to know, getting out of the system. I'm going to hand this. Well, all right, I'll finish this one. You'll write this one out, won't you? Any other questions for the sponsor of the bill? Representative Fritz.
Thank you, Mr. Chairman. To the sponsor, I appreciate what you're trying to accomplish here, but I have the same kind of question that Representative Halsey does too with that. So I don't know that I can support the bill.
Any other questions for the sponsor?
Chairman.
Representative Towns.
Mr. Chairman, along those same lines, what it becomes a hodgepodge of, how you're going to apply the law at that particular point in time, okay? Because I've always thought there was a cutoff and it was based upon a definitive amount of money,
It is.
okay? And so that leaves too much subjectivity in it as well, if we begin to look at it like that. So, even though guns are dangerous, we know that. Pocket knives are dangerous, we know that. But so I have the same concerns, Mr. Chairman.
Chairman Howe.
Thank you, Mr. Chairman. And you raised a question in my mind. By separating this out, let's do for instance, if someone broke into a home, assaulted the homeowner, stole everything they have in the house, how would that penalty compare to the penalty that we have for stealing a gun?
You want to go out to legal and let them answer that?
That'd be fine. I'm just curious
Okay.
how that
We're out of
compares.
session, legal.
Michelle Fogarty, Legal Services. So aggravated burglary is burglary of a habitation, and that's a Class C felony. Especially aggravated burglary is burglary that results in serious bodily injury to the victim, and that is a Class B felony. So for burglary, though, it's just the entering with the intent to commit a crime. What you actually steal is separate.
So the penalty in this bill would be lower than if someone committed aggravated burglary. Is that what you're saying? Or
They could be charged with both.
with both? Okay. Thank you.
Any other question for legal? All right, we're back in session. Any other questions for the sponsor of the bill? All right, seeing none, we're voting on House Bill 1720. All those in favor say aye. Aye. Opposed, no. No. Yeah, I'm not sure. So let's take a roll call vote. Go ahead.
Representative Davis? No. Davis votes no. Representative Fritz? Fritz votes no. Representative Gillespie? Yes. Gillespie votes aye. Representative Hardaway? Representative Howell? No. Howell votes no. Chairman Halsey?
No.
Chairman Halsey votes no. Representative Johnson? Representative Johnson votes present, not voting. Leader Lamberth?
Yes.
Lamberth votes aye. Representative Moody? No. Moody votes no. Representative Russell? Russell votes aye. Representative Towns? No. Towns votes no. Chairman Doggett? No. Chairman Doggett votes no. Chairman Halsey, you have 3 ayes, 7 noes, and 1 present not voting.
Okay. Bill fails.
Members, let's go to item number 11, House Bill 2702 by Representative Littleton. You're recognized. There are 2 amendments with this bill.
Thank you, Mr. Chairman. I'd like to go with 16700.
Amendment Code 16700. You're recognized on the amendment.
Thank you, Mr. Chairman. This bill came from the Juvenile Ad Hoc Committee that I served on a couple of years ago. As amended, it requires a juvenile court to transfer a child to to be held and tried as an adult if the child was at least 14 but less than 18 years of age at the time of the alleged conduct and charged with the offense that would be a felony if the was committed by an adult and involving the use of a firearm.
Any questions on the amendment? Seeing none, we're voting to attach Amendment Code 16700 on the House Bill 2702. All those in favor say aye. Aye. Those opposed? Ayes prevail. You adopt. On House Bill 2702 is amended. Any questions for the sponsor? Seeing none, we're voting to send House Bill 2702 as amended on the full criminal. All those in favor say aye. Aye. Those opposed? No. The ayes prevail. You move forward. If you wish to be recorded as a no, please see the clerk.
Thank you, Mr. Chairman and committee.
I'm looking for him. Number 8. Item number 8, House Bill 994 by Representative Kiesling. You're recognized. There are 2 amendments here that have been filed. Is there one that you wish to proceed with?
Chairman, thank you. And that would be, I'm sorry, I wasn't ready for this. The only amendment is my drafting code is 16052, sir.
All right, Amendment Code 16052. You're recognized on the amendment.
And yes, please. And the brief explanation is I'm identifying a violent crime, which includes any criminal offense or of intentional or knowingly causing bodily injury or reasonable fear of bodily injury to another, and B, any degree of arson, intentional or knowing assault, burglary, carjacking, intentionally or knowing homicide, kidnapping, robbery, sexual battery, rape, and human trafficking. With that, Mr. Chair.
All right.
Questions? That is my
Questions?
description of.
Thank you for that. Questions on the amendment? Seeing none, we're voting to attach Amendment Code 16052 on the House Bill 994. All those in favor say aye. Aye. Those opposed? Ayes prevail. You adopt. We're on your bill as amended.
Thank you, Chairman. And members, House Bill 994 is known as the Citizens Arrest Bill. This bill protects victims of crimes. It's about equal rights for men and women. It's also about putting weaker or more frail people on the same footing as physically stronger people, and about having the law side with the victim of a crime, not the criminal. This bill is a bipartisan effort to ensure the criminal goes to jail, again, not the victim. I want to thank my colleagues in both parties for their support on this with this effort, and also thank my colleagues, including the committee members, for their critical input and help since this bill was first presented to you, which has allowed us to arrive at a well-balanced and thought-through piece of legislation that strengthens victims' rights, prevents injustice, and makes our communities safer, provides clarity, and also has reasonable boundaries. While current law allows for self-defense, while an attack is imminent, the moment the attacker decides to stop, the law then starts to discriminate between people who are strong enough to overpower the criminal, as they are allowed to hold the attacker until police arrive, and those who are weaker, who have let the attacker go unless they want to risk getting charged with a felony themselves. An example of that would be if a woman gets attacked and raped. The moment that the rapist stops and walks away, she is, under current law, no longer allowed to hold him by displaying a deadly weapon until law enforcement arrives. If she does, then she's guilty of a felony. Representative Hardaway pointed out exceptionally last time how difficult it can be for a victim to make a legal determination on the spot. Under current law, it is easy for the non-legally savvy victim to accidentally end up in felony territory when standing up to the attacker. This emboldens criminals that causes victims to fear not only the attacker, but also the law. We should make the victim or the criminal fear the law instead, and that is what the bill does in summary. Again, I want to thank you for your encouragement and the enormous bipartisan support for this legislation. It's already passed the Senate Judiciary, for those FYI, with 6 ayes, 0 nays, and 3 present not voting. And over 30 members, almost 40, they've already signed on to the bill as well, and I deeply appreciate that. With that, I conclude these remarks, Chairman. I'll defer back to you because I know there's a testimony ahead. So with that, I'll back to you.
Thank you for that explanation. We will go out of session. We do have several on the list to testify. First on my list is a Toby Meyer. If you'll come forward, you'll see the on-off button up there. If you'll press that, introduce yourself for the record. You'll have 3 minutes for comments.
Thank you, Mr. Chairman. Thank you, committee members. I don't intend to take up a whole lot of your time because I know you'll have a full schedule, but I wanted to make sure that I'm here. Toby Meyer, T-Rex Arms for the record. Wanted to make sure that I'm here in case there are any questions regarding this legislation. I think at this point, the committee members are probably pretty familiar with this bill. What it does is close a gap where the victim of a crime may actually unintentionally run afoul of the law and end up committing a felony. And it's basically intended to make sure that the victim who already is at a disadvantage of not choosing the confrontation, whom the conflict is brought to by the attacker who has all the practical advantages of choosing the location and the victim and the means, that the victim in that situation doesn't have to fear the law in addition to the attacker. Thank God most of the DAs in this state already apply the law in a way that's pretty similar to as if this bill was already passed. I'm aware of 2 cases where something actually happened, where somebody was attacked and actually held the attacker until law enforcement arrived. And thank God those 2 people were both not charged. But if I'm not mistaken, a case actually happened, I believe, to a constituent of one of the committee members, where somebody actually did get in trouble for firing a warning shot at the time and then holding the person until law enforcement showed up. And if I'm not mistaken, that led to a bipartisan bill that created what's now TCA Section 3911-1322 subsection B, that protects the person from getting charged with firing a warning shot under a municipal statute. But unfortunately, it only protects against the charge under that municipal statute. So that's where this bill actually fills the remaining gap and makes sure that the person cannot then be charged, for example, with aggravated assault. With that, thank you very much. And
all right, thank you. Questions for the guest, Representative Towns?
Excuse me. So how do you contrast this between stand your ground law that's on the books in Tennessee?
Thank you, Mr. Chairman. Thank you, Representative Towns. So the self-defense statute right now, Section 3911-611, allows you, basically says that you do not have to retreat first, assuming that you're not engaged in criminal activity, in a felony or a Class A misdemeanor. You do not have a duty to retreat first before you use force in order to defend yourself against an imminent attack. If you're in reasonable fear of imminent threat to your life, serious bodily injury, or grave sexual assault. The problem is that this requires imminence. So you're okay as long as the attack is imminent. The problem is the attacker who already chooses the location and the timing can also choose when to walk away. For example, if the attacker encounters more resistance than expected and walks away, and you say, well, you're not just getting out of this, I'm calling the police, and you hold that person, you're under current law, 3911-621, allowed to hold that person using force. But that, of course, requires that you're physically stronger than the attacker. If you threaten deadly force, it's treated the same way as if you're using deadly force, and you're risking getting charged with a felony for that.
So with this adaptation, you would be able to use force, is what you're saying, and not be charged. And that's the gap you're speaking of.
So right now you're allowed to use force, but you're not allowed to use or threaten deadly force. This basically, in other words, allows you to, for example, threaten with a deadly weapon without having to physically engage.
But I did. I switched back. Adaptation. If this becomes law, so then you would be able to use the force without having the penalty of a felony, is what you're saying. If it becomes law.
Well, so you'd be allowed to threaten deadly force,
Right.
correct? Correct.
Right.
You'd not be allowed to use deadly force unless the threat becomes imminent again, correct?
Right. Okay. Thank you.
Any other questions for our guests while we're out of session? Seeing none. Thank you for being with us. Next on my list is Steve Crump, Tennessee District Attorney General's Conference. If you will, state your name on the record, and then you'll have 3 minutes for comments.
Thank you, Mr. Chairman and Committee. My name is Stephen Crump. I am the Executive Director of the Tennessee District Attorneys General Conference, and we have grave concerns about this bill. And I think I speak for the rest of law enforcement when I say that this is not a bill that is frankly needed in this state at this time. As an elected DA, as an assistant DA, there were a number of circumstances wherein we observed citizens who used the power that you're talking about in this bill to hold criminals at bay and to wait until law enforcement got there. And I have not, and as I sit here, I still have not heard of a single person charged in the state of Tennessee for doing just that. There are people who get charged, but it typically is when there are actions outside of just that, or it's when they do not act in a reasonable fashion. This bill, while I certainly, and I appreciate Representative Kiesling, we've had a number of discussions about this, and I have a great deal of respect for him and what he's trying to accomplish. But this is not the correct approach. This could lead to the unintended consequence of, imagine, if you will, in the city of Memphis, where there is a significant gang problem, where you have two rival gangs who each decide that the other is committing what they believe is a crime in which they are authorized to use this force to effectuate the citizen's arrest of the other group. What could that look like? In the Senate, their response was, well, if two gangs start shooting at each other, is that a bad thing? Well, it is a bad thing if a doctor from St. Jude's Hospital is killed in the crossfire. So I would ask you to consider very strongly the unintended consequences of this bill before you vote for it. Thank you very much.
Thank you for that. Representative Johnson.
I don't know. I guess to me, this kind of sounds like stand your ground on steroids. What do you see happening with this bill? I mean, you talked a little bit, but specifically, I think that people need to understand, what this is going to yield or what it can yield.
We don't know exactly what it will yield. Our concern, though, is that in a circumstance where a person makes a decision in an instant, they're either going to make the right decision or the wrong decision. And if it's just not a good idea, we think, to create a scenario that encourages people to do this in nonviolent offenses.
Yeah, well, thank you. And what I see is situations where after somebody can talk about being attacked, but how does anybody know who wasn't at the scene and that sort of thing? I just think it's dangerous. But thank you,
Chairman Holsey.
Thank you, General, for being here. You can't use deadly force to protect property. You can't use deadly force to shoot a fleeing felon. But I think what he's trying to accomplish, and I signed on the bill, and I agree with the principle, that if somebody's committing a violent crime against me and I defend myself with a weapon, and then I say, you're not going anywhere till the police get here, I don't want to ever be charged in that scenario or be risked committing a felony because I held somebody at gunpoint till police arrived. Now, I do see where some of this could play out wrong, and I do have a problem in one regard with the bill, even though I signed on to it. In that I think that it very well may be that something as nonviolent as spitting in your face could induce this kind of reply under the way the bill's written. I have a problem with that part of it. But how do you answer? Because if there's no means for somebody to do this, then you just become a regular victim and suck it up.
Mr. Chairman, I can tell you as both an elected DA and again as an assistant DA, on more than one occasion, we had circumstances where citizens found somebody breaking into an outbuilding at their property and held them at gunpoint until law enforcement got there. And there was never even a thought that we would charge them. It never even occurred to us to charge them. In the circumstance that we heard about where there's a carjacking, I cannot imagine the thought process that would lead not just the district attorney, but a grand jury to indict where there's a carjacking and somebody manages to get the better of the carjacker and holds them at gunpoint and then is charged with a crime because, well, at that point, the threat had ceased. The threat has not ceased until the defendant is in the back of a car. And so I don't know what could come. And certainly I understand the circumstances like occurred in St. Louis, Missouri, where two property owners were charged for coming out on their front porch and holding weapons. I get that. I certainly understand Kyle Rittenhouse in that circumstance. And I understand what folks are trying to get at. But what I'm saying is, having appeared in front of grand juries, having declined charges in these circumstances, the mindset in Tennessee has been well established by many, not just the General Assembly, but by the people who live here, that if somebody comes on your property and they're going to try to steal something, and I hold you until somebody gets there, I've just never seen anybody charged under that. Certainly, I've seen people charged for discharging a weapon when there was not good cause to believe. That the display of deadly force, in my mind, is different than the use of deadly force. And I think that's the way I practiced as an assistant, and certainly was the way I approached things as the district attorney. So I understand what you're saying, and certainly under the circumstance that you listed, it is a problem. But I can tell you that as somebody who made charging decisions, it never occurred to me and would never occur to me to do this.
Representative Towns.
General, look, let me go back to something you said, a couple of things. First thing, whether you have criminals, gang members, or whomever shooting at each other, it's a bad thing, regardless of who's doing the shooting. Not to mention the stray bullet that may hit any doggone body, okay? It's just bad altogether. People are not dispensable because they're criminal at this point in time, okay? I want that on the record, okay? Second thing is this, is that what he's talking about is the gap that's there. With you being the man that has the experience, what do we do to close that gap? What do we do from your perspective?
I don't think there is a gap. I guess that's what I'm saying. I understand what you're saying, and I understand that. I'm just telling you what I observed in practice. I'm telling you that the 32 elected DAs, I've spent the last 10 years with them talking about issues just as this. Our legislative committee is comprised of elected DAs from all different walks of life and all different political persuasions. The ones that aren't on the committee have the ability to weigh into our legislative conference. And nobody has said to me or to the committee or to the group of elected DAs, well, we got to have this, because if not, I don't believe there's a gap. I understand there may be a perceived gap, and there may be places in the country where the mindset is different than the folks that live here in Tennessee. I think we are a state that believes in the ability to defend yourself, the ability to defend your property. Now, I can tell you in Monroe County, Tennessee, we presented a case to a grand jury where a fellow shot and killed somebody who was trying to steal his 2 wave runners. And the grand jury considered it and no-billed it. Now, we presented that. I presented it not because I thought there was a particular, that I thought the grand jury did exactly what I thought they would do. And so what I'm saying to you is I just don't believe that the gap that you're talking about, it may exist in terms of theoretical positions that people can discuss, but in terms of what the people of Tennessee believe, what the prosecutors of Tennessee practice, I don't believe that gap exists.
Mr. Chairman, let me give you a scenario. Okay, coupled with the fact that our law enforcement member thinks that there's a possibility, hate to be charged with something if he thought he was in the right. So let's say that you had a baseball bat, somebody's on your property, okay? And you decided to use the baseball bat because you thought the guy was going to be provocative. Are you able to charge him then, the person that property has been violated or car is being stolen? I know you can't harm people or kill people for property being stolen, but what say you then that occurs, not the gun, but a baseball bat or a knife?
I think the situation is the same. If somebody comes on your property in Tennessee and they are acting in a way that is threatening in your mind, and you say to them, leave, and they don't leave, and you get a bat or a knife or you get whatever else, there are certainly scenarios that you could pose where somebody could be charged with an aggravated assault under that set of circumstances. Certainly. I mean, if somebody is not acting in a way that is threatening and you use a knife, you use it, there's certainly we can pose a scenario, but in the one you posed where you believe somebody is a threat, again, I just don't see, there would have to be more than that before I would consider charging somebody with an aggravated assault.
Okay. Mr. Chairman, let's say here again, all the people that you're working with currently, they have this mindset that is similar. I'm flipping the switch and everybody's gone. You got new people there that don't think like you. What happens then?
Then I think they'll find a way to interpret this statute that is before us here that will make it ineffective. The concept is not going to be what it says. The concept is going to be what's the mindset, what are the factors, what are the facts that exist, and they'll emphasize other factors over the ones here. There's no statute that you can draft that can keep a prosecutor from going in front of a grand jury and saying, these are the facts that are important, and grand jury, you should take these facts. That you can't create a statute that's going to stop an abuse by a government official. It's like a DA. I say to this, and I said this to people when I was elected, I said, if you pay attention to nothing else when you go vote, pay attention to who's elected as your district attorney. Because the ability that they have to change the average life in Tennessee is different than anybody else in the entire state. The courts have said it is the most powerful office in Tennessee, and the courts have said that it is the one that has frightening in terms of its ability to be abused. And so I guess what I'm saying to you is you can put all the words on paper you want to, but the paper will mean what the DA says it means when they go into a grand jury. And so if you're going to say that these words are going to change that, I'm sorry, it's not. You have to elect good people who exercise good judgment and who recognize and represent the values that we currently have in Tennessee, or that we've historically had in Tennessee. And so the idea that you can create a statute that will stop somebody from abusing you in the office of the district attorney is not possible.
Well, Mr. Chairman, you proved my point. That's exactly what I'm saying. That's exactly what I'm saying, because if someone leaves that is not in tune, not as astute, not as historically sound of Tennessee culture, and they could do something totally different. It is a frightening position. I've often said that. It is the most powerful because it's subjective. And if you got a mean guy or lady or someone that has all these thoughts, okay, it can be very dangerous. And it can be very dangerous. So I'm saying or hearing that possibly that there need to be some kind of parameters. I don't know exactly what they are. I would go to your office for it because you'd experience one with it, because it's too much subjectivity to it. And you don't want to get into race and gender and all this other stuff that someone could decide to do this, that, and the other. You have almost absolute power to do it in terms of taking somebody's freedom away. And that is frightening, very frightening. Okay, but by the same token, though, I'm just a little guy, okay, at home, in my community, walking the street or walking the community with my wife, or just getting some exercise, and somebody jumps out to threaten me. Well, my first inclination, not what the law said, my first inclination as a man is to defend myself, okay, by any means necessary. That's just how it is. First law of nature, preservation, okay? And that's what we what we have in a world today that is not friendly internationally, domestically, locally, is just not friendly because people have lost a lot of morality about how they feel about other human beings, or how they feel about human beings, period. And that's dangerous. And so people need to be able to defend themselves without going too far. Okay, no question about it. You need to be able to defend your children, your wives, your property without going too far. But when emotions rain down, it becomes a problem because you see red. Okay. And what we have to do as men of the law and women of the law have to figure out what's the best approach so that we maintain freedom and civility towards each other and justice towards each other. So there again, I would be looking for you as a champion of the state to try to help with things like this, to come up with something that needs to be done, because you do it the right way doesn't mean the next joker is going to do it the right way. I don't trust it like that. Politics, temporal, that things change. Okay, we here today and gone tomorrow. Such is life. Okay, and these other people may not think the same. So what do we do to enshrine and make sure that it goes that way? Well, you got to have some words. That's what we go by. We go by words. The Constitution, words. The Bible's words. Contracts are words. That's what we go by. You know. Now you can always twist things, but people know when old folk got the old saying, "I smell a rat." We know when we smell a rat. Everybody knows when they smell a rat. You know how to deal with a rat too. Okay. So I'm saying, we want to try to make it right as best we can for our citizens. Okay. Mr. Chairman, thank you. Thank you too, General.
Certainly.
Yes, sir. Thank you. Any other questions for our guest? Seeing none. Thank you for being with us. Oh, sorry. Representative Howe.
Thank you, Mr. Chairman. Just very briefly, the stand your ground doctrine that we have, that statute, doesn't that cover a lot of what we're talking about here?
That's what I thought.
Yes, Chairman Howell, we believe it does. We believe that, again, I think it goes back to within the total context of defense of property, defense of third persons or others, the self-defense, stand your ground law, we believe covers very much these circumstances.
Thank you.
All right. Thank you. Any other questions? All right. Thank you for being with us. Next on my list is Elizabeth Stroker and a Matt Perry from the Department of Safety. If you two will introduce yourself for the record, you'll have 3 minutes each for comments.
Colonel Matt Perry, Tennessee Highway Patrol. Thank you, Chairman. Committee, again, we understand, the intent, some of the concerns. Our biggest concern around safety is one that this bill allows you to threaten the use of force, but not use that force. So warning shots and things like that police officers are not allowed to do. We wouldn't want a citizen firing a warning shot. Second, if I see somebody threatening to slap another person and pull my gun out because that's violence, and that person now feels threatened because I pulled my gun out and shoots me because they're defending themselves. These are some of the concerns we have. Kansas City after the Super Bowl, you've got two people that are exercising something similar to this. Shooting at each other. Speaking of the gang member things, not that those people necessarily were, but you get two rival gang members or these people in Kansas City firing guns at each other because they're offended or threatened or say they saw a violent act occur. It's not the two people shooting each other that's a concern. It is, obviously, but the bigger concern is all the citizens and the innocent bystanders standing around that eventually get shot, and in that case did get shot.
Elizabeth Stroker, Legislative Director, Assistant General Counsel for the department. And again, just wanted to focus on some of the things that were said. This bill, again, would not allow for someone to shoot a warning shot. And this bill would not allow for someone to use deadly force. And as the Colonel stated, you would have situations where someone witnesses, someone spitting in someone's face, and they could then hold them at gunpoint. And that person who is being held at gunpoint could then pull their gun out or any weapon they may have and use deadly force against that person. And they would not have any penalties associated with that. So we understand what the sponsor is trying to get at, and he is a great friend of law enforcement and of the departments. It's just there are so many unintended consequences that this could create that could put the public and law enforcement in a spot where it creates some dangerous situations for others, and law enforcement responding not knowing who the good guy is if they show up on two people having guns pulled out or a knife and a gun pulled out on each other. And so because of that, we think that it's just not in a spot where it is ready to go, that it needs a little bit more thought. As the DA said, a lot of this stuff is already covered under current law. And so really just looking at this a little bit more and making sure that we don't do something that could have these really dangerous or unintended consequences that we know the sponsor absolutely does not intend to have.
All right, thank you for your testimony. Questions for the guest? Seeing none, thank y'all. Oh, Representative Towns? Go ahead, sir.
Colonel, let me ask you a question. Just say, someone comes to your house on your front yard under your carport, okay? And you may have just had a stack of wood. You get ready to rebuild a shed, this, that, and other. You go out and you have your gun in your hand. You don't know who these people are, okay? So what happens is is the homeowner charged in that scenario? Somebody's backed up to your house. Could be in the daytime, not nighttime. But you give me both answers. But and you just bought a load of wood. You're gonna repair some stuff. Okay, so in your mind, you think somebody, hey, maybe gonna get you wood, da 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 da, and you go out because these are strangers, and you have your gun in your hand, or you draw your gun up to let people know because they're strangers. You're a little intimidated. You don't know what's going on. How does that play out legally?
Colonel Matt Perry, Tennessee Highway Patrol. That's a tough one. So are they taking my wood, or they're just on my property?
Well, they have come onto your property where your wood is. They've come onto the property where you're going towards your wood, and you just happen to see it, and you go out, try to figure out what's going on. But explain both if you.
Okay. Yeah. I'll try to not be a trooper. I'll just be a citizen. I think
Always a trooper.
That's right. That's right. I think I would just ask them what they're doing on my property and ask them kindly to leave. Speculating too far past that is going to be tough.
Mm-hmm.
That'd be better to speculate further for the DAs, not us.
But if they didn't do that, would they be? Let's say it was at night.
If they didn't leave.
No. Let's say change the scenario. It's dark, and you see people moving up on your property, looking, and you just bought a couple $1,000, $3,000 worth of wood, or what have you, nails or what have you, paint, whatever. It's under your carport. Now it's at night. Now, what would you do? You'd ask them to leave at night.
I would, but you're asking the trooper not to be. I'm trying not to be a trooper, but I'm going to go out there and ask them to get off my property if I don't know them, recognize them, or they don't have business there.
Okay.
So that getting too far past that is hard for me to speculate.
Okay. Thank you both.
Any other questions for our guest? Seeing none, we're going to go back into session. Thank y'all for being with us. First on my list is Representative Johnson for the sponsor.
Thank you, Mr. Chairman. I guess laws like this, to me, harken back to days when citizens arrest laws, back to a time when we were empowering white Southerners to capture runaway slaves. I really do feel like this is a dangerous bill that sets a dangerous precedent. And, in listening to our law enforcement officers, they seem to have a good grasp of how they think this is going to work. And I think that we should listen to them.
I have no comment.
Thank you for that. Next on my list is Representative Howell.
Thank you, Mr. Chairman, and I appreciate the testimony today. And I've, over the last week, looked at this bill, and I have the greatest respect for my colleague, the chairman, as a friend. But I can't get comfortable with this bill. I do like the stand your ground and the castle doctrine. And to me, defending yourself is a sacred right. But when I look at this bill, to me, it lacks clarity. There's ambiguity, and of course, the possibility of unintended consequences. And I'm just not comfortable with it. So I would move that we move it to summer study.
There's a motion for a summer study. It has been seconded. All right, sponsor, you have any comment?
That what I'm here, will of the committee.
All right, there's been a motion to send House Bill 994 on to a summer study. It has been seconded. Without any objection, voting on the summer study motion, seeing none, we're voting send House Bill 994 as amended to summer study. All those in favor say aye. Those opposed? The ayes prevail. It goes to summer study.
Thank you,
Which
Chairman.
will be recorded as a no. Please see the clerk. Let's go to item number 20. Item number 20, House Bill 2380 by Representative Parkinson. Item number 20, House Bill 2380 by Representative Parkinson.
Thank you, Mr. Chair, and thank you, committee. We do have an amendment.
Which amendment code do you wish to proceed with?
I'm showing 017721.
All right, Amendment Code 17721. You are recognized on the amendment.
Thank you, Mr. Chair and committee. If you'll give me just a second to walk us through, why we're here. Recently there was a decision made by the Tennessee Supreme Court in Falls versus Goins, and that decided where the Tennessee Supreme Court decided that in order to get your rights back, you have to apply two sections of the code. One of the sections was created in the 70s. The other section was created in 2006. The first section in the 70s speaks to governor's pardons and other items of that nature. The second part of the code and that was created in 2006 speaks to, you paying your child support and getting everything in order before you can even apply to have your rights back. And if you need to, I'm not Representative Boso, so I can't spit these codes out like Bible verses, but if we need to refer to legal, then I'd be happy, if Mr. Chairman, if you need to. And so in that decision, the Supreme Court said that it is not one pathway or the other pathway, but it is both pathways combined. And that was their interpretation of the law, because when the law in 2006 was created, it did not cancel the law that was created in the 70s that's in our code. And so what this bill does, it does two things. It clarifies the language so that we can interpret our code specifically to reflect on how the Commissioner of Elections was restoring people's voting rights before Fall's decision. Secondly, what it does also is it allows individuals to go after specifically the rights that they are eligible to receive. Now, let's say, for instance, if a person was convicted of a financial crime or something and they couldn't receive their financial, the rights to any of the rights to execute a fiduciary office. Understandable, but that doesn't mean that they should not be afforded their ability to get their gun rights back. It does not mean that they should not be afforded the ability to get their voting rights back, or one of the others. And so what this bill does, it allows individuals to go after specifically those rights that they are afforded based on the crime that they committed after they've done everything that they are supposed to do by law to get their rights back. And so just to, when we talk about citizenship rights, what the rights, when you receive a felony, this is what you lose. You lose the right to serve on a jury. You lose the right of suffrage, the right to hold public office, the right to execute a fiduciary office, and the right to possess a firearm. Those are the rights that you lose when you receive a felony. Now, there is absolutely no reason that we should say it has to be all or none. You know, if an individual has paid their debt to society and they are afforded the ability to get some of these rights back or one of these rights back, they should not be excluded because they can't get them all in one lump sum. And so that's what this bill does. Senator Paul Bailey, who's carrying the bill on the Senate side, and I think there's other members that have signed on to it also, passed this bill in the Senate with an 8-0 vote. So, you know, the bill has merit. And let me be clear also, you know, out of transparency, you know, I sat down with the Commissioner of Elections. We sat down multiple times actually to try to work through this bill, and we also worked with Department of Safety to get it in the posture that they needed it in also. And you know, I think that we got like 99% of you know, the concerns that the Commissioner of Election had. But one of their concerns was the fact that we were using language. If you look on the amendment, we're using language on page 2 of the amendment. I think it's B1, the notwithstanding language, because, you know, we didn't open up all of the parts of the code that speaks to full citizenship rights, and they're everywhere. I'm being honest with you, they're everywhere, right? But we did add the language, the notwithstanding language, so that we can make sure that we're clear on our intent when it comes to this legislation. And so I just think it's important, you know, that we give people an opportunity to get those rights that they're afforded. Some people will be able to possibly get their right to bear arms back. Some people get their right to vote back. Some people get their right to serve on a jury back. Some people might want to become a bail bondsman because they hadn't committed a financial crime. And so this will allow them to work in financial spaces. And so, and Mr. Chair, if you can, let me get a roll call vote on this also, please.
And that is that your explanation of the
That is, sir.
amendment?
Yes,
All right, we're on the amendment. Questions on the amendment? Representative Johnson?
So, the way I understand it, I like your bill. You can get some rights and not others. I'm curious, I don't know if you were in here earlier, but we had a bill where if you were a young person, say 17, you would lose your gun rights from 18 to 25. And so my concern is the recent decision from our election commission where if you don't have your gun rights, you cannot vote. And so would this bill address that? Like you could get, because you couldn't get a gun does not prevent you from being able to vote.
Yes, sir.
Yes, thank you, and thank you for that question, Representative Johnson. So you know, in speaking about how, you know, the Falls decision, right? So I was curious as to how the election commissioner got to the position that, you know, what we were seeing in the media, that you had to have your gun rights back in order to get your voting rights back. And sitting down and talking to him, I understood how he got to that space and how he got to that space. And I think this is worthy of discussion. This is why we're even talking why I even drafted the bill. How he got to that space was because in our code, it only speaks to full rights of citizenship. And when it speaks to full rights of citizenship, the only thing that gives reference to what a right of citizenship is in the state of Tennessee is our Constitution. Our Constitution says a citizen has the right to bear arms. That's the only rights that, you know, our code speaks to. So that's why we have this language now to clarify, you know, what are all the rights that are taken away from a felon? What are all the rights that can be restored? And we're adding the caveat that if you cannot get one, you should be able to get the other. We shouldn't hold the rest of them against you. And so that's what this bill does. Thank you for that question.
Any other questions on the amendment? Seeing none, we're voting to attach amendment code 17721 on the House Bill 2380. All those in favor say aye. Oh, I'm sorry. Excuse me. I need to back up on that. You requested a roll call vote.
Yes, sir. Thank you.
Sorry about that. So, Madam Clerk, take the roll.
Representative Davis. Davis votes aye. Representative Fritz. Fritz votes aye. Representative Gillespie. Gillespie votes aye. Representative Hardaway. Representative Howell. Howell votes aye. Representative Holsey. Holsey votes aye. Representative Johnson. Johnson votes aye. Representative Lamberth.
Aye.
Lamberth votes aye. Representative Moody. Moody votes aye. Representative Russell. Russell votes aye. Representative Towns. Towns votes aye. Chairman Doggett. Doggett votes aye. Chairman Doggett, you have 11 ayes.
All right, thank you. So we are on the bill as amended. We do have people here to testify. Do you want?
No, we're fine.
Okay.
We'll move forward.
All right. First on my list is Chairman Holsey.
Yes, sir. And I wasn't running from you this morning. I was in another committee. Couldn't get to you. I'm sorry.
Thank you, sir.
We've dealt with some other voting issues, right of suffrage versus right of citizenship, the fragmented pieced together meal that we put together in this, the whole deal dealing with restoration of these kinds of rights has been piecemeal and fragmented for the last 20 years. It's a mess. Most of those we have rolled over to a summer study to join up with our legal team, who has promised me that starting this May, they are going to systematically dismantle all of the existing code and package it up in a new bill that we will run to fix this. And I just want you to know, if you're amenable to that, that's going to happen.
Thank you, Chairman and Chairman Halsey. I'm hoping and praying that this committee will pass this bill on to the full committee, and we can try to move this bill, because even if we move this bill, that does not stop us from cleaning up the code to make it even better next year. And so I hope that we will not use that as a reason to postpone giving individuals the opportunity to get their rights. And you know, this is a good bill, well thought out bill, bipartisan piece of legislation that will be beneficial to a lot of Tennesseans. So I'm hoping and praying that we do not go that route on this bill and use that as the reason, you know, for not passing the bill. Now, and let me say this also, and I think it's important to note. If we look at that, the language that I used in the notwithstanding language, that speaks to the very issue that you're talking about. I had to use that language notwithstanding because there are other areas in the code, you know, that speaks to full citizenship rights. And we use that language to make sure that we were clear on our intent about this bill, but it does not stop us from cleaning up the rest of the code. As a matter of fact, my intent was to come back next year once our wonderful legal person, Michelle, got it completed, to come back with the legislation that is the cleanup portion of the legislation. But I want to speak to that notwithstanding language and the fact that things need to be cleaned up. But I'm looking at, I got a bill right here by our very own chairman, who I appreciate, notwithstanding. So that means that something needs to be cleaned up. I got another bill here by you, Chairman Halsey, that uses the language notwithstanding. That means something needs to be cleaned up. These are bills that were passed this year. Leader Lambert, notwithstanding, means something needs to be cleaned up. Another one from you, Chairman Halsey, notwithstanding, means something needs to come. I'm not trying to put you on the spot, but what I'm trying to say is our code, another one, Chairman Halsey, another one, Leader Lambert, Chair Lady Hazelwood, but I'm not trying to put anybody on the spot. What I'm trying to say is this: our code is so convoluted and jacked up. All of this stuff needs to be cleaned up, and it's our job to go back and clean it up. But let's not hold up legislation like we did not hear. These bills were passed in this committee this year with notwithstanding legislation. So if we didn't hold these up because the code needs to be cleaned up, I beg you, please don't hold this one up because the code needs to be cleaned up. Let's be fair about it, and let's pass this bill out because it's a good bill. Let's pass this bill out on its merits. It's a good bill. We got individuals back here, and and the reason why I asked them just to hold off on speaking is because I don't want this thing to get any more convoluted or become more of an issue than what it is. This is a good piece of legislation that will help these individuals that are sitting back here, you know, watching this process, and other Tennesseans. So let's do it on the merit of the bill, not on politics, not on, you know, to kick the can down the road. And I'm not accusing anybody of any of that. All I'm saying is we've passed bills out of here with the same language that I have in my legislation. And this language is added because
The code is convoluted. So I'm asking you to please, let's be fair about this and let's pass this bill out.
Representative Parkinson, I asked if you didn't want anyone to speak, but I do recognize that there are some names that may not be with the group. So I'm going to ask about Stephen or John Ware, Stephen Brown, and Deanna Jenkins. Do any of you wish to speak? I didn't mean to allow him to speak for you. You may not be with his group.
I've wrote it down, so I try to be very concise.
Absolutely.
I'm a little bit nervous.
That's okay. You're fine. Look, we're going to go out of session. And there's an on-off button right there in front of you. If you will, push that and then introduce yourself for the record. You'll have 3 minutes. And I apologize for any confusion there.
Hello. Yep.
Okay. Mr. Chairman, I'm Stephen Brown, resident of Wilson County, 8-year U.S. Army vet, and I'm in support of Bill 2380, which separates gun rights from voting rights. In December of 2023, I had the honor of receiving my full citizenship rights restored, excluding my gun rights. Fast forward to February 2024, I learned through the Wilson County Office of Elections that my application for the voting registration was denied because I didn't have my gun rights restored. As a husband, father, and a business owner, I find myself seeking more opportunities to become an example to others who have fallen short and need encouragement to go forward. As I continue to stay encouraged by the perceived hurdle could cause others to feel discouraged, the right to vote carries so much more weight than the act of voting, as it is a privilege and an honor to be a part of the political process in a country that I served and am proud to be a citizen of. For myself and others who want to continue moving forward as productive citizens and separating voting rights and gun rights allows us to be fruit on the vine that continues to bear fruit versus not being versus dying on the vine and not bearing fruit. So even as I speak to you right now, there are so many reasons why I support this bill, House Bill 2380, but I can tell you from the experience that I've had that the goalposts continue to be moved as I continue to meet requirements. And I just say as a citizen and as a veteran that I believe the price is paid for the offense that I committed. And I sit before you as a restored man. Thank you for your time.
Yes, sir. Thank you.
Okay, well, first I want to take time to thank you for hearing me today. My name's John Ware. I live in Hohenwald, Tennessee in Lewis County. And I'm here because I want my voting rights. Not being able to vote makes me feel like a non-American. When I was talking to an elected official, I used to feel as if I had to beg to be heard, and as if I was a secondhand citizen. However, after speaking with Leader Lambert last month, he assured me I was being heard, and it was the first time in a long time I'd felt like an American. It actually felt good that I could come up and I didn't have to cringe. I've been able to talk to several of you since then. But at any rate, I served my country in the United States Navy. After my conviction, I served my time. Since then, I became a productive citizen, becoming involved in my community by volunteering my time at the Hope Center for those struggling with addiction and alcohol, doing both group and individual counseling, serving as a local Celebrate Recovery leader, helping others in their recovery, and being part of the food distribution ministry, delivering food to the doors of the elderly and the disabled. As I've been going through the process of restoring my vote right, I've come over several hurdles
over the past 4 years. And as I was becoming ready to start the final stage of restoring my right to vote, there was a decision made in January that presented a new roadblock saying I had to have my full citizenship rights, which included gun rights. I have an aggravated assault charge dating back several decades ago in another state, which prevents me from carrying a gun, and I'm fine with that. The bill before you with House Bill 2380 removes that roadblock, allowing me to present my case before the courts and allowing them the decision of whether I should have my rights to vote. In conclusion, I'm asking you to support this bill, allowing me the chance to vote according to my conservative Christian values that I hold dear, and allowing me to be an active participant in my community and be part of the democratic process for which I serve my country to protect and which makes our country so great. And again, thank you for taking the time to hear me.
Thank you for that. Questions for our guest? Representative Towns?
Mr. Chairman, I'll start off by saying we certainly did not need to miss this testimony from these two fine men. To you all, thank you for what you've done, brothers, for protecting the country, and as well as thank you for what you're doing now, still trying to protect the country. Okay, appreciate it. Okay, thank you. That's both of you. Our lives as human beings, we're fractured subjects. Okay, but where I come from, we still believe in forgiveness. We still believe in that we're gonna make a mistake again sometime, and we still need more forgiveness. Amen. I'm talking about myself. Okay, we need more forgiveness and more forgiveness and more forgiveness. But what you all have done, you make it compelling to me that it should be a no-brainer. And when you say that you don't feel like an American, that breaks my heart. That breaks my heart, especially after you've gone and fought for the country. It breaks my heart. It really does. That's a sad way to be in terms of your own personal feeling. But that's how you feel because you can't vote. You don't feel restored. And you're talking to the group that need to be able to do something about it. Okay. And aging on the vine, we need to take those grapes and make fine wine out of it and serve it to you all for what you've done. So I appreciate your testimony, Mr. Chairman. Thank you.
Yes, sir. Thank you. Any other questions for our guest? Seeing none, thank you both.
Thank you.
For your time and for being here with us today. Deanna Jenkins? Nope. All right, we're going to go back into session. All right, we're back on the bill now. On my list, I have Leader Lamberth, and he is gone. So, members, any other questions for the sponsor on the bill as amended? Representative Fritz.
Thank you, Mr. Chairman, and to the sponsor of the bill, I appreciate you carrying it. You and I have talked about this. I think we ought to restore rights. And I was remiss not getting my hand up early. I may be a little bit out of order, Mr. Chairman, but I appreciate the two veterans that come and testify. And I just, I support what you're doing. I have cautions. We're about to open up everything here, and I think there's maybe some good guidance, as you and I whispered, in pulling this all together and doing it right the first time. But with that, I just ask for your consideration on that, and I do support what you're trying to do.
Thank you so much.
Representative Howell.
Thank you, Mr. Chairman. And thanks for coming to my office and having a discussion about your bill. And I'm like the other representative, I do support what you're trying to do here. And you made a distinction in the bill. You made a distinction the way it's written in the Constitution and the way it's written in your bill concerning citizenship rights. Could you elaborate on that?
Thank you, Mr. Chair. Yes, sir. In the Constitution, it says a citizen has the right to bear arms. That's what the Constitution explicitly says. And that's the only reference to what a citizen right was. But so we had to explicitly spell it out in our code so people understood the rights that individuals lost and what their rights are. And so that's what we're doing in this legislation.
Okay, thank you.
Any other questions for the sponsor? Seeing none. We're now voting to send House Bill 2380 as amended to full criminal. Madam Clerk, take the roll.
Representative Davis? Davis votes no. Representative Fritz? Fritz votes aye. Representative Gillespie? Gillespie votes no. Representative Hardaway? Representative Howell? Howell votes aye. Representative Halsey?
No.
Halsey votes no. Representative Johnson? Johnson votes aye. Representative Lamberth? Representative Moody? Moody votes no. Representative Russell? Russell votes aye. Representative Towns? Towns votes aye. Chairman Doggett?
Yes.
Doggett votes aye. Chairman Doggett, you have 6 ayes and 4 noes.
House Bill 2380 as amended and moves on to full criminal.
Thank you, Mr. Chair, and thank you, committee.
Let's go to item number 20. That's what we just did? Yes, sir. Sorry about that. Item number 24. House Bill 2068 by Representative Jernigan. All right, Representative, you recognized, there is an amendment or two, I think. You have one you'd like to proceed with?
Chairman, I'd like to proceed with your amendment, please.
All right, that'd be 17271. Is that the amendment code you wish to proceed with?
It is.
All right, amendment code 17271.
And
all right, you're recognized on the amendment?
well, Chairman, since you're moving the amendment, would you mind explaining since it's your amendment?
I will, be glad to.
Thank you.
It maintains the Class A misdemeanor. It raises the fine to $2,500 for spectators and makes clear the intent to own, possess for the purpose of breeding or exhibiting poultry.
I considered that a friendly amendment. Thank you for working with me on it, and the amendment's going to make the bill, and that's what I'd like to go with.
Okay. Any questions on the amendment, Representative Johnson?
Yeah, on the explanation, is the felony taken away or just for spectators?
No, the felony's taken away. We increased it on the spectators.
Okay, thank you.
Any other questions on the amendment? Seeing none, we're voting to adopt amendment code 17271 on the House Bill 2068. All those in favor say aye. Aye. Those opposed? Ayes prevail, you adopt. We're on the bill as amended. Any questions for the sponsor? Seeing none, we're voting to send House Bill 2068 as amended to full criminal. All those in favor say aye. Aye. Those opposed? The ayes prevail, you move forward. If you wish to be recorded as a no, please see the clerk.
Thank you, Chairman.
Yes, sir. Thank you. Item number 26, House Bill 1947 by Representative Howell. You are recognized. There is an amendment.
Thank you,
Couple
Mr.
of
Chairman.
amendments.
Yes, I have 17152.
Okay, amendment code 17152. You are recognized on the amendment.
The amendment makes the bill, Mr. Chairman, so I can
You can
explain it
move adoption.
now or after.
All right, we'll, without objection, we'll vote to attach amendment code 17152 on the House Bill 1947. All those in favor say aye.
Aye.
Those opposed? Ayes prevail. You adopt. We're on 1947 as amended.
Thank you, Mr. Chairman. This bill originated out of a conversation that Senator Lowe and I had with our sheriff following two cases where two deputies were almost died, went into cardiac arrest after being exposed to fentanyl while making an arrest. And both had to be NARCAD, one into cardiac arrest. And so we're looking for a way, and in that case, the extended circumstances only amounted to a 90-day misdemeanor. So what this bill does is it increases the discretion of the district attorney in how they prosecute under drug and murder statutes. It creates trafficking penalties for distributing fentanyl across county lines, increases the penalty to a Class C felony. And we have worked with the DA's Conference, the Sheriff's Association, and TBI also worked with us on this bill, and I would move passage.
Thank you for that explanation. Any questions for the sponsor on the bill? No questions. We're voting to send House Bill 1947 as amended to full criminal. All those in favor say aye.
Aye.
Those opposed? The ayes prevail. You move forward.
Thank you.
Let's go to item number 27, House Bill 2302 by Representative Howell. You are recognized.
Thank you, Mr. Chairman. I don't have an amendment, do I?
There are a couple listed
Is there?
here.
I believe the one I have is 17292.
That's 17292, the amendment you wish to proceed with?
Yes.
All right, you're recognized on the amendment.
I believe the amendment makes the bill.
All
Mr.
right,
Chairman.
well, let's vote to adopt this amendment. All those in favor of Amendment Code 17292, attaching it to House Bill 2302, say aye. Those opposed? Ayes prevail. You adopt on House Bill 2302 as amended. You're recognized.
Thank you, Mr. Chairman. This bill 2302 is known as the Ben Creedich Act. It came to me from Senator Massey when one of her constituents died as a result of someone who was under the driving while impaired. His name was Ben Creedich. He was a young man with autism. He advocated for students with special needs and those with disabilities. Ben had previously testified here in the Senate committee advocating for equal access, for example, on campus housing for disabled students. Tragically, not soon after he had testified, Ben was struck and killed by an impaired driver while walking on Kingston Pike in Knoxville. The driver had recently been administered Narcan. Narcan is a prescription medication. I think most of you know what it's used for, commonly administered to reverse opioid or drug overdoses. But while it often reverses the symptoms and can save a person's life who has overdosed, the drug can still remain in the person's system, according to the National Institute on Drug Abuse. So what this bill authorizes is a first responder who administers Narcan to a person to notify that person of the risk associated with driving within a 24-hour period and made aware that they could be ticketed for driving while impaired within that 24-hour period. The bill also adds the driving within a 24-hour period after being administered Narcan to the DWI code 5510401. That's what the bill does, Mr. Chairman. Thank you.
All right, any questions for the sponsor, Representative Towns?
Mr. Chairman, thank you. Mr. Chairman, you're giving me an education there. I did not know that it stays in your system that long. Okay. Now, and you made this technical, maybe biological, medical. Next question is that can that stuff react with other drugs that you're taking after facts? You know, some people are on medicine and different things. Will it? And we may not know that. We could find that out. But what you're trying to do, I support it. No question about it. But do you think it could react with other medicines?
Well, having no background in medicine at all, I can only assume that it might, because it has a direct effect on opioids in your system and allows you to recover from an overdose and function, but it's still in your system and you should not be driving, according to the National Institute on Drug Abuse.
Well, I appreciate the insight, because I just thought I never thought about it. Once you inject somebody with Narcan, we're doing the best thing in the world, saving their lives, but there's still some residual that we need to consider. So thank you for bringing the bill.
Thank you.
Any other questions for the sponsor? Seeing none, we're now ready to vote. Send House Bill 2302 as amended on the full criminal. All those in favor say aye.
Aye.
Those opposed? Ayes prevail, you move forward. Item number 28. Oh, okay. Sorry about that. I was out of the room. Item number 29. House Bill 1930 by Representative Gillespie. You're recognized.
Thank you, Mr. Chairman and committee. This bill is the Parental Accountability Act. And if you don't mind, I'm going to read a letter here from a constituent. It says, "Dear leaders, in the wake of the serious juvenile crime in Shelby County, we must get a hold of our youth. It is not their fault that they have no supervision or the wrong supervision. No one likes rules and answering to authority, but we all know how beneficial it can be in the long run. What we have today are parents who have no parenting skills and have abandoned the hard and exhausting work of raising children in these hard times. I understand, but that does not negate the fact that our youth still needs guidance. Parents have abandoned the work of parenting, but they have not abandoned the desire to cover up the error of their children's ways. The entire household is benefiting from the spoils gained by the crimes. Somebody knows these kids are not in bed at night. Somebody knows that a teenager was not at home at 11 p.m. when curfew begins. Somebody knows that the car their teenager brought home was not the family car. Somebody knows who is in their household is not attending school. Somebody knows their son or daughter has provisions without proper means. The parents may be negligent, but they are not clueless as to what's going on. They may even be complicit. While every parent has the right to govern their homes as they please, you as city leaders have a duty to protect the citizens of Shelby County when ineffective parents spill over the community. What this bill does would require the juvenile court judges to assess a restitution order not to exceed $1,000 to any parent upon the second and any sequential offenses committed by a juvenile. This is designed to reimburse law enforcement for the expenses related to the crimes and incentivize parents to supervise their children more closely following their first juvenile court experience. The restitution for the expenses incurred by any law enforcement agency in responding or investigating the delinquent act will be as follows. No less than $250 for a misdemeanor act, no more than $500 for a felony act, and it shall not exceed $1,000. If a parent is found indigent, the parent can work the restitution off in community service. And with that, committee, I ask for your vote.
Thank you for that explanation. First on my list is Representative Johnson.
Thank you, Mr. Chairman. So a couple of questions. One, I did work with trouble kids and sometimes trouble kids who get in trouble. I would have parents who would actually report their kids on their own because maybe it was a grandparent that was had a teenager that they were taking care of, or just a single parent who couldn't handle that teenager. So my question is, if you called to report your own child for this, are you going to get that fine?
Yeah, thank you, Mr. Chairman. I'm sorry, can you repeat the last part of that question? We're having a little issue up here.
So my question was, if it's a grandparent with a teenager or maybe a single parent with a teenager, they're not able to control them. I've had parents that have called and reported themselves on their own child because they really needed help. So would those parents be penalized and that charge be made to them for reporting their own child?
So you're asking me if a child has already been found delinquent in the court system twice and a parent calls on their, I'm confused. What are you asking?
Well, sometimes parents report on their own kids because they can't manage it. So if they do this, are they going to be charged that fine for doing so? This came to me from folks concerned about that.
I suspect that the judge would take that into consideration because this again is putting this into the juvenile court judge to assess this restitution order.
Okay, so we're hoping that's going to happen. What about a situation where a foster parent has gotten a child. They're not responsible what happened before, but are they going to have to make those payments when they've gotten the foster child now, but had nothing to do with what came before?
So you're asking if someone with already 2 prior delinquent acts enters into foster care?
I'm talking about penalties being assessed to people who were not responsible at the time that it happened. And
All right.
this is another concern of folks that are dealing with these situations.
Okay, so in the situation of where a child has already been found delinquent 2 times and then the next day enters into a new foster family, that's what you're talking about? Or that's what you're asking?
It
Because
might
that's the
be
only way that this
or
would
it might have
align on that.
happened. The second one might have happened with a foster family as the child was getting acclimated. And will that foster parent in this new situation be given those fines when they hadn't been responsible for the first situation and just recently had the child come into their custody?
It is my understanding that if your child is found or the child in your custody is found delinquent by a juvenile court judge more than twice, so this would be the 3rd offense, then the parent or guardian or custodian or whatever legal definition you want to call them would be called in front of the court, and then the court would assess whether or not they would be fined.
So yes, they could possibly find someone who just got custody of the child. Thank you. Appreciate it.
Thank you. I want to apologize. I just noticed I did have someone on the list here to testify. Josh Spickler. Right here? Nope. All right, we'll keep going. Representative Fritz.
Thank you, Mr. Chairman. And Representative, I really like what you're trying to do there for the parental accountability. I think that's a good thing. I have just one question regarding, and it goes back to the foster parenting or adoption. Do we put some of these high-risk kids at risk of not finding a foster parent if we didn't modify this slightly to accommodate for that? Certainly not recommending that we allow a foster parent to allow delinquency either, because I know what your heart is on this. My question is there a way to modify it slightly with perhaps DCS help to get us to that point?
Thank you. Yeah, I mean, I can talk to my Senate sponsor. I believe this is already passed in the Senate, but we can certainly, I can certainly entertain that as a friendly amendment if you were to propose that at another time.
Representative Towns.
Mr. Chairman and Chairman Gillespie, I think Chairman Fritz is right on point, as well as my colleague Representative Johnson. And there has to be, when the letter was read, okay, that whomever forwarded to you, it made me think about my childhood as a kid growing up. And there were certain things you weren't bringing in my mother's house. I don't care if it was food or clothes or bicycles or skates or marbles or anything. You couldn't do it. Because if she didn't buy it, daddy didn't buy it, it wasn't going to be brought in that house. And there has to be more accountability with raising your children. The police officer always will be after the fact. Parents, as everyone have to do their job. However, what we do many times in lawmaking, we go from one extreme to the next. It's a knee-jerk reaction because all of us are we're tired of crime. Everybody is. Even a criminal does not want to be shot. And it's a problem. And we're trying. We don't know exactly what to do. But the overreach is a problem as well. But I can see it working with just a little bit of tweaking, as Representative Fritz was saying. We could tweak it a little bit because you got to give an out to a 75-year-old grandmother who's raising a grandchild that's hard-headed, start having sex, drinking alcohol, and doing what they want to do. She can't control him. She can turn him in the first time. She can turn him in the second time. She can turn him in the third time. But this hard-headed little butt's not going to listen. And she's living on 75 years old. Her check may be $1,000. Social Security, what have you. So we need to have an out for people like that to prove that they're trying to deal with raising their child properly, and he's just a knucklehead. How do we deal with that knucklehead? But you can't penalize the grandmother. with the little money she's trying to pay the little utility bill and buy a little medicine stuff and others. So we need to try to tweak it a little bit, and I can support it. We tweak it and make sure we're not penalizing these mothers and these seniors and folk that are trying to do the right thing. They can testify or they can, prove that they're trying to do that. So I'd love to see that amendment, Representative Fritz, where we try to help make it a better bill. Mr. Chairman, thank you.
Yes, sir. Thank you. Response? Okay. Anyone else on the list? I've got Leader Lambert here. Nope, pass. All right. Any other questions for the sponsor? Seeing none. Voting to send House Bill 1930 to full criminal. All those in favor say aye.
Aye.
Those opposed? No. The ayes prevail. If you wish to be recorded as a no, please see the clerk. I'm going to hand it off for item number 31 here.
Okay, we're moving to item number 31, which is House Bill 2206.
Motion.
Got a motion and a second for Vice Chair Gillespie. You're recognized, sir.
I'm sorry, Mr. Chair. Thank you.
Did you hear that? Your amendment is, I'm showing is 014549. Is that correct with you?
That is correct. Yes, sir.
Okay, motion and a second on the amendment. We're attaching 014549 to House Bill 2206. All those in favor say aye.
Aye.
Opposed, no. Your amendment is attached, sir. Proceed, please.
Thank you, Mr. Chair and committee. Okay, this bill is a little, I guess, different, but we get to see a lot of stuff in this committee. It's one of those bills that actually took a lot longer to iron out than I originally thought it would. It was brought to me by my sheriff. Basically, right now, there are sheriff's offices and other law enforcement officers across the state that use training dogs or cadaver dogs to search for bodies. And to train those dogs, they use human remains. And transporting those human remains right now for those training purposes is actually against the law. And this is something that's been done for a while. It's a much bigger issue nationwide than I think we may have opened Pandora's box a little bit. But after consulting with the Department of Health, the TBI, the Sheriff's Association, the Medical Examiner's Office, the University of Tennessee, and a lot of other entities, this will just allow for those law enforcement agencies that are using these dogs for training purposes to be able to transport these human remains and use the best practices to, I hate the word dispose, but the proper disposal methods for the human remains. As you can imagine, there's a lot of regulation involving this, and that's pretty much what the bill is. And with that, I welcome any questions.
Okay, you've heard the explanation. There are questions for the sponsor. Seeing none, we're voting on House Bill 2206. All those in favor say aye. Aye. Opposed, no. Ayes have it. Moves to calendar and rules, I believe. I'm sorry, it does move to full committee. I was trying to skip you over there and put you in the fast track, bro. All right, where are we next? Item number 33, Russell. All right. Thank you. That brings us to item number 33, which is House Bill 2794 by Chairman Russell. You got a motion? Got a second? Chairman Russell, you're recognized on 2794, and I'm showing two amendments.
Thank you, Mr. Chairman, and I'm only going to run 017596.
Motion. Hang on a minute, I gotta make sure I have that amendment. Yes. It's the
And it
last
makes
one.
the bill.
All right, we're voting, got a motion to second to put attach, or to attach 017596 to House Bill 2794. All those in favor say aye. Aye. Opposed, no. Ayes have it. The amendment is attached if you want to proceed.
Thank you, Mr. Chairman, committee. While the overall violent crime rate in Tennessee fell 3% in the last 10-year period from 2012 to 2022, crime rates for certain violent crimes have actually increased. For example, The rate of aggravated assault offenses rose 7%. The rate of rape offenses rose 20%. And the rate of homicide offenses rose 39%. Meanwhile, the rate of violent crimes that went unsolved rose 21%. In 2022, the clearance rate, the rate at which crimes are solved, was only 36, meaning that 64% of violent crimes went unsolved. Research from the National Institute of Justice shows that increasing the perceived likelihood of apprehension and punishment is one of the most effective methods to deterring crime. Therefore, House Bill 2794 creates the Tennessee Victims Act, which seeks to create a grant program for law enforcement agencies to improve their solved cases, thereby providing swifter justice to criminals, more expedient relief for victims, and better public safety outcomes for all Tennesseans. All law enforcement agencies would be eligible for the grants, and the allowable usages would be hiring more investigators, purchasing technology to improve laboratory turnaround times, and support service for victims. The entire program is subject to appropriations, so the General Assembly can fluctuate the amount of money allocated to the program depending on the economic condition of the state in any given year. With that, Mr. Chairman, I renew my motion.
All right, you heard an explanation of the bill. Any question for the sponsor? Seeing none, we are voting as amended, House Bill 2794 to full criminal. All those in favor say aye. Aye. Opposed, no. Ayes have it. Bill moves to full. Oh, that's mine.
All right, let's go to item number 41. House Bill 2943 by Representative Towns.
Thank you. Mr. Chairman, thank you for taking that out of order. I'm over here real nervous about my Senator Kyle. This is her bill, and I don't pass it, she's going to kill me. So,
well, hey, you've got an amendment here, 144.
Yes, sir.
45.
Yes, sir. Thank you.
All right, you recognized on the amendment.
Yes, sir.
Question's been called in on the amendment. I'm sure the amendment makes the bill.
It does.
So we'll go ahead and attach that amendment. All those in favor of attaching amendment code 14445 on the House Bill 2943, say aye. Aye. Those opposed? Ayes prevail. You adopt your bill as amended. Go ahead.
Well, and Mr. Chairman, this is coming, and members, this is coming from a real situation that happened in the district where, oh boy, it's really horrible. But the background is that a kid with her friends had a little party over at the house, a little slumber party, bunch of kids and girls. And the dad came in one night, and while they were doing the party, and he told his daughter to go in the room and go to bed. Well, that was a bad move from the start. It left the other girls out there who were her friends, so she's no longer hanging out with, and she's in bed, and he's out there. And what he did, he exposed himself, okay, to the kids, okay? And so what this seeks to do, because they were 13 years old, they were a little bit older, but what this seeks to do is to take that age up in terms of criminality to 17. So nothing happened to him because they came right in on the wire. So she brought it to our attention to try to make modifications and change that law. So if he does that to a group of kids that's 17 years old, he can still be prosecuted. And essentially that's what it does, members.
All right, thank you for that explanation. On the list I have is Representative Gillespie.
Thank you, Mr. Chair and sponsor. Thank you for bringing this. This unfortunately, at the time, it was not in my district, but this is my district, and I know the family. They live right down the street from me, unfortunately. The family of the victim, that is. I also know the other person as well. But thank you. This is something that was very frustrating when it happened. Our former DA tried to do everything she could on this, but the law is what the law is. And I think this fixes a pretty dramatic oversight. So thank you, and I fully support it.
Yes, sir.
Mr. Chairman, thank you for that, and I'd love to have you sign on to it, so you can feel free to be co-sponsor. We'd love to have it.
All right, Representative Fritz.
Thank you, Mr. Chairman, and thank you for the bill. I just had one question under Roman numeral 4 on the amendment. It uses the words "without the consent of the minor," and can a minor consent is my question. Am I missing something there?
That's 7. You know what?
Depends on the age.
Yes, sir, Representative.
I don't want to get technical, so we're going to have to get legal involved, but I would think that it would depend on the age. Somebody 17 years old may be able, a 13-year-old certainly not, 14, 15-year-old certainly not. So it may be put in there for that, but at 13, certainly not.
Would you like to go out of session?
If you don't mind, sir, that would be great.
Could I ask one follow?
Go ahead before.
One follow-up, Mr. Chairman, before we got a question. Again, completely supportive. I just think that we should be careful using those words "without the consent of the minor," because we might drive ourselves in a direction that would imply that children can consent to sex, and we should not do that.
Yes, sir.
And Mr. Chairman, point well taken. And a friendly amendment is also welcome. I don't have a problem with a friendly amendment at the next level as well, because I think you're right.
Do you still want to go out of session here from legal?
If he's satisfied, I don't need to. Okay.
All right, let's go out of session.
She wants to hear from legal, so we can do
Hear
it.
from legal
Let's do it.
services.
Thank you. Thank you, ma'am.
Michelle Fogarty, Legal Services. I believe that language is in there to prevent bringing in consensual acts between teenagers.
Any follow-up for legal?
Thank you. I'm still scratching my head on. I understand what legal's saying. I'm concerned about leaving that kind of language in, that it infers or implies something we do not want to infer or imply.
Representative Johnson.
And my question, I guess, is, isn't there something where 13 to 17-year-olds can consent if the person is only a certain number of years older than them? Or does that enter into this or not?
So rape of a child is rape if the victim is more than 8 but less than 13. So this is consistent with that. And then I believe you're probably referencing the statutory rape offenses, which mitigated statutory rape is the victim is at least 15 but less than 18, and the defendant is at least 4 but not more than 5 years older than the victim. There's staggered, and I think the reason for that is to not criminalize what may be consensual acts between.
But for just exposure, that wouldn't.
No, those are the rape offenses, but in this bill, it's without the consent of the minor. And it's talking about exposure.
Any other questions for legal while we're out? Seeing none, we'll go back into session. Questions for the sponsor on the bill as amended? Seeing none, we're going to vote now to send House Bill 2943 as amended on the full criminal. All those in favor say aye.
Aye.
Those opposed? Ayes prevail. You move forward.
Mr. Chairman, I'm going to go with 37, if you don't mind, sir.
Representative, item number 37 was general subbed in the Senate. So we are working off of bills that have
yes, sir.
moved on. So
Yeah.
item number 40 of yours is still active.
Mr. Chairman, I heard they had a little drinking problem over in the Senate, so we're gonna go to 40, okay?
So item number 40,
Drinking
House Bill
water.
2863.
Okay, let's see. Thank you. Got a second?
Yep. The amendment code is 15372. You're recognized on the amendment if you wish to proceed with it.
Thank you.
Do you want to use that amendment?
Yeah. Mr. Chairman, I was trying to. Yeah, we can use them.
Okay.
No problem.
All right, let's vote to attach amendment code 15372 on the House Bill 2863. All those in favor say aye. Aye. Those opposed? Ayes prevail. You adopt or own your bill as amended. You're recognized.
Well, Mr. Chairman, the amendment rewrites the bill and requires a person who commits a second or subsequent offense of aggravated reckless driving to attend a driver's educational class and have their driver's license suspended for at least 6 months, but no more than 1 year. It requires the law enforcement to seize the person's vehicle, second subsequent offense of aggravated reckless driving if the perpetrator of the offense is the sole owner of the vehicle. Okay, and what's happening is that, I mean, we've talked about it. Representative Gillespie and others have brought bills that deal with this reckless driving in certain cities, especially some of your major cities where people are driving 100 miles an hour, coming behind you, and they scare you to death. They really scare you to death. And we're trying to get at that and re-educate people as to how to drive on streets where everybody else has to use the same streets to go to work and buy groceries and go to healthcare appointments and all that. That's essentially what it does, Mr. Chairman.
Thank you for the explanation. Any questions for the sponsor on the bill as amended? Seeing none. Voting to send House Bill 2863 as amended on the full criminal. All those in favor say aye.
Aye.
Those opposed? Ayes prevail. You move forward. Representative Towns, I've got you down here on item number 44, House Bill 1520. To present that one.
Mr. Chairman. I signed on to the bill, Mr. Chairman. As you know, one of our committee members, Mr. Hardaway, is actually he's in Memphis right now. So we're going to take a stab at his bill here. And that's 1520. And if I may.
Yes, sir. There is an amendment. The amendment code is 5582.
Second.
All right. We're on the amendment. The amendment does rewrite the bill. Questions called. We are voting to attach amendment code 5582 on the House Bill 1520. All those in favor say aye. Aye. Those opposed? Ayes prevail. You adopt. We're on the bill as amended.
Yes, sir, Mr. Chairman.
Yes, sir.
It's similar to the bill that's filed, but it does rewrite the bill. This amendment expands the pilot program to any county agreeing to participate via resolution adopted by a 2/3 vote majority. Requires the county to pay for the program with local or grant funds, create a reporting requirement for participating counties. So in other words, it's opening it up if there are others that want to participate in this pilot program that authorizes juvenile courts to retain the jurisdiction of a juvenile offender found until their 21st birthday. If the judge finds that the youth is amenable to treatment and rehabilitation, and additional treatment and rehabilitation may be necessary beyond DCS committed period. But that amendment expands and allows those to opt in by 2/3 vote, Mr. Chairman.
Any questions for the sponsor? All right. We're voting to send House Bill 1520 as amended to full criminal. All those in favor say aye. Aye. Those opposed? Ayes prevail. You move forward. If you wish to be recorded as a no.
Thank you.
Please see the clerk. Would you like to present item number 49?
Is that Harris, Mr. Chairman?
No, sir. This is another Hardaway.
Hardaway.
We're still in the Hardaway calendar here.
Mr. Chairman. Mr. Chairman, let me go to Harris and come back. I read these and see what those are.
All right.
Okay. I think he was 19.
He was number 18.
19, I believe. 19, something of that nature. Let's see. Try to clear this calendar up for us today.
Yes, sir. It was number 18.
Is it 18?
Yes, sir. House Bill 2515.
Let me get on it there, sir. $25.19.
I'm sorry, it's, we're on House Bill 2515.
Let's see what we got here.
Right. Item number 18. I'll give members time to get there. Yeah, you're right. You're right. I'm sorry about that. You're not on that one.
No problem. No problem. I didn't sign on the other one there. So
All right.
19.
So you were not on that. I wrote you down on the wrong one.
Yeah.
Sorry about that.
No problem.
So Representative Harris is not here today, and there's no one signed on to his bill.
Can we roll it, Mr. Chairman? I may sign on it. Can I do 19 and now we'll look at how we dispatch that one. Give me a minute.
Number 19 has failed in
Oh,
the
it did?
Senate, so we won't
Jumps
be,
up to, okay, very
yes,
good.
sir, we won't be
Okay.
taking up those bills.
But Mr. Chairman, if you don't mind, you can roll it in to the hill and I'll see I can see what can I do.
All right, we'll,
Okay.
without objection, we'll roll item number 18, House Bill 2515 to the hill. All right, you want to tackle item number 49? You and I
49.
both are signed on to it.
Well, Mr. Chairman, you the chairman, you're a better man than me, so I'm gonna let you have it.
Well, I thought you were more articulate than I was. That's why I was going to let you have it.
49.
Representative Gillespie is on it too. He
Okay.
may want to jump all over it.
Second.
All right.
Oh, my goodness.
There's a motion and a second on House Bill 2961. So,
oh boy.
Item number 49. If I need to pass the gavel off, I will to talk about it.
That's what I have to do.
Do I need to?
Well, Mr. Chairman, we'll take a little stab at it. What it is, it looks like a TASA study, okay? And don't let me get in the high weeds because I hadn't really delved into this. As introduced and directed Tennessee Advisory Committee on Intergovernmental Relations, TASA, with the assistance of Tennessee Bureau of TBI, the District Attorney General's Conference, and the Department of Safety, to study the feasibility of a Shelby County crime lab and the impact of such crime lab on public health, safety, education, housing, and the economy for citizens and visitors in Shelby County. Now, some years ago, we did have a crime lab there. They moved that crime lab that we had in Shelby County, Mr. Chairman. Oh, they moved it 100 miles away to Jackson, Tennessee. And certainly with our city being 1 million plus people, we need a crime lab there in order to expedite the findings and analyze whatever the findings are so that people can have justice in court. So essentially, that's what it does. It does increase state expenditures by $50,000. So, but that's what it is, Mr. Chairman.
Thank you for that thorough explanation there. Representative Leader Lamberth is on my list.
Move previous question.
Previous question has been called. Any objection? Seeing none, we're voting to send House Bill 2961 on the full criminal. All those in favor say aye. Aye. Those opposed? The ayes prevail. It will move forward. Great job.
You're very kind.
Boy,
you got a lot of
we're on
bills
me
in there.
now, right? Leader Lamberth.
Thank you, Mr. Chairman. I know that Representative Hardaway is not here today, but I would like maybe Representative Towns to let him know that his bills seem to have gone better in his absence than they did in his presence.
Don't tell him that. His ego, don't tell him that.
Certainly a more concise explanation, for sure. I need my.
I'm not on these other bills.
All right, that brings us to item 35 on the calendar, House Bill 2684. Is there an amendment?
There will be no amendments here, sir.
Okay, no amendments. House Bill 2684. You have a motion and a second. You're recognized on the bill.
Thank you, Mr. Chairman. Last year, we had some legislation that dealt with the bail bond, the bail bonding industry, about how there was an effort to get some information in front of the judges and magistrates, and also have defendants for certain level of offenses to be entered into NCIC. That language that was brought last year said that 10 days from the failure to appear is when all this information had to be entered. What this bill does is going to move it to 10 days, to have 10 days to have that information entered once it is received by the law enforcement agency, the agency that would be entering the warrant and this information. This is certainly not a fix to the issue that we're seeing right now, but it does help somewhat. This language does help. And so that's why we're moving passage.
Okay, you've heard an explanation of the bill. Any questions for the sponsor? Representative Johnson.
Thank you, Mr. Chairman. Is TBI okay with this legislation?
Thank you. I have not had any conversations with the Bureau.
Question been called on the bill. We're voting on House Bill 2684 to go to full. All those in favor say aye. Aye. Opposed, no. Ayes have it. Moves to criminal full.
Thank you.
Oh, we got another one? My bad.
Item 36.
That brings us to item number 36, which is House Bill 2693, also by Chairman Doggett. Is there a motion and a second?
Second.
We got a second and a motion. Is there amendments on this one?
I don't know.
I'm showing one.
Maybe. 16694.
That's what I'm showing. Okay, we've got a motion and a second to add 016694 to House Bill 2693. All those in favor say aye. Aye. Opposed, no. Ayes have it. The amendment's on. Please explain the bill.
Thank you, Mr. Chairman. Establishes that the District Attorney General is not required to file a complaint to require involuntary care and treatment for a person who is found incompetent to stand trial due to intellectual disability and a criminal offense due to the in a criminal offense due to intellectual disability that also determine whether the person is subject to involuntary care and treatment at the hearing in which the person is declared incompetent, provided that 2 certificates of need have been submitted to the court. It requires the court to direct the Department of Intellectual and Developmental Disabilities to conduct an evaluation to determine if the person meets the criteria for involuntary care and treatment, and if no certificate of need has been submitted prior to the hearing in which a person is declared incompetent, requires the court to conduct a hearing to determine if the person must be committed to the custody of DIDD if the court subsequently receives 2 CONs. I don't even know if that's a word or not.
Maybe subsequent.
Yeah. Subsequent, yeah, that's it. Subsequently, yes. What time is it?
It's about time to adjourn.
That's
I feel
right.
good about it.
Thank you. That's it, Mr. Chairman.
Move previous question. Okay, previous question been called. There's an objection. We're going to vote for previous question or not previous question. All those in favor of previous question say aye. Aye. Opposed, no. The ayes have it. Previous question prevails. We're voting on House Bill 2693 to go to full. All those in favor say aye. Aye. Opposed, no. Ayes have it. Moves to full.
Thank you.
Who you need? Who do you need?
Thompson.
I'll check outside. Hang on.
We do still have one bill that was on the hill, that we had rolled to the hill, number 18. Item 2515. Representative Harris. He's not here. Without objection, we will take this off notice. House Bill 2515 off notice.
No Thompson.
Representative Ritchie. House Bill 1925. This is item number 55. It was general subbed in the Senate. What our intent is today is the bills that have not been heard or failed in the Senate or was not calendared, they will all be taken off notice at the conclusion of this, excuse me, at the conclusion of this meeting here today.
I'll sit here and wait.
Do you want to say something? I mean,
Thank you, Chairman. Yeah, I just want to come in for House Bill 1925. I know it's taken gen subbed over in the Senate, but this is something that's extremely important to our district. And folks had asked me to run this all the way across the state. Has to do with there's a circuit court of Benton County already ruled it unconstitutional, unlawful, and unenforceable for what TWRA has been doing all the way across the state of Tennessee, based off of a 1920 Supreme Court ruling and a 1984 Supreme Court ruling. And with that, we're looking to codify that lower circuit court ruling. It's going through the appeal process. My desire and intent was not to disrupt those, the appeals that was going forward. And that's, I guess, some of the concerns that's out there. But at the end of the day, we need to protect personal property rights. We need to protect our Fourth Amendment. And I just wanted to come up here and state that. And with that, Chairman, I request this be taken off notice and we will bring it back again. Thank you.
thank you. We will take care of that here shortly. Leader Lamberth. Leader Lamberth.
Thank you, Mr. Chairman. Mr. Chairman, the remaining bills on the calendar either are not on notice in the Senate or failed in the Senate, or the sponsor is not present. At this time, I want to thank you for your service as our chairman of this committee. You've done a phenomenal job. We still have several weeks of work to do in the session, but at this juncture, I'd make a motion to adjourn.
Is this just for the first calendar or the second calendar too? We're still on the first calendar. My bill number 17 is on the second calendar as well. Okay.
Okay, Leader Lamberth.
Thank you. If there are members that have something live or they want to state to, I'll withdraw my motion. But again, I mean, at this time, we are all kind of here and have other work to do, but I will withdraw my motion if there's statements to be made. And I think there was testimony. A representative came back in. So Mr. Chairman, I will withdraw my motion for now.
All right, thank you. So just as a reminder, we will not be taking action on bills that have not been heard in the Senate, that have not passed, if they failed, whatever, if they're not even in the proper committee or calendared. So with that, I know Representative Thompson had asked me earlier today, but Representative Pearson's been sitting in the room, so I'm going to allow him just a couple minutes to speak on one of his bills that he had, and then I will say we do have a second calendar today that are bills that have either been not calendared in the Senate, ones that have been rolled to, but we'll end up discussing that calendar here momentarily. But Representative Pearson, I'll give you, a couple minutes just to make some statements here on your bill before we end up finishing this calendar.
Thank you, Chairman. And so after this, just for clarity, after this calendar, we'll have the second calendar come up, because I know I have a few bills on that one.
That is my intent, that we will have a second calendar that we'll look at, but all the ones that are on that second calendar in the same posture as some others. So we'll end up removing them back to the clerk's desk as well.
Okay. Will I have the opportunity to speak on those or not?
If you would like to combine it all into one right now, I'll give you that opportunity, or how would you like to proceed?
I can speak on those individually. I just want to keep in line with however you're going to end
Sure.
end the first calendar and then go to the second one. Or you want to keep?
We will, but procedurally, we probably will. I'll give you just a minute on that second calendar just to speak briefly, and then we'll dissolve of all those on there as well, since they're not moving.
Thank you. Thank you so much, Chairman, and thank you for the opportunity to speak on this one. This bill is related to waiting periods. If you go and purchase a firearm today, it would allow for you to have a 15-day waiting period. The concern that this legislation addresses is individuals who, in the heat of this emotional anger or frustration, go and purchase a firearm and they go and commit an atrocity or a murder. This would just institute 15 days of a waiting period after they've met the other qualifications. And for most people who own firearms, it isn't a problem, because you're not about to go out and commit a crime, and you're not going to purchase this weapon and then have it as a straw purchase and give it to someone else. And so this bill seeks to address that issue. And so with that explanation, I understand this bill has not moved forward in the Senate, and so would like to take it off notice.
Thank you for that. I'll end up doing that for us all at the end of it. I will say your bills were in the delayed bills committee over there. I was hoping that you would have had opportunity to encourage your Senate sponsor to help move that process along, so we would have an opportunity to consider some of these things. But thank you. I apologize for your delay for sitting here, and I appreciate your patience. So thank you. Representative Towns, you've got something you want to say?
Yeah, of course, Mr. Chairman. Along that delay period, and I've known of cases where people simmer down. Okay, they calm down and their thoughts change and it goes away. But that impulse will cause somebody to lose their life. So we may still need to look at it again to figure out what can we do to bring that about. Because if minutes or seconds save lives, why not? And I know it will. Especially we were talking to somebody in the hall just a minute ago. I think it was a 19-year-old there with his girlfriend. Chased his girlfriend through the community. 19, you're a different brain. Okay. Ended up catching her firing a pistol, didn't hit her, and killed an innocent bystander. Okay, 19 years old. Okay, now his life is ruined, absolutely ruined for whatever reason it was, that judgment. So if you had somebody like you or somebody like your dad or mom talk to them, or some older person talking to them, settle them down, it'll help. It will. So thank you. Okay.
Thank you so much.
Yes, sir.
Thank you again,
Thank you.
Chairman, and hope to have the Senate move a little quicker this next time.
Absolutely. Thank you. All right, Representative Thompson. I think you found yourself in a similar posture where you had a bill in the Senate that ended up not making it item number 25. It was House Bill 1302. It was general subbed over there. So, but you do have someone here that wants to that had signed up for testimony, has been waiting for a week or so to do this, traveled great distance. Is that right?
Yes, Mr. Chairman, I appreciate it. And I wish it had been heard in the Senate, but the sponsor was out. I believe she was had some medical problems, and unfortunately that was not heard then. But if the committee could hear this lady's testimony, it would be appreciated. It might give some at least some information that could be considered, next year, considering the all you people are young people and might be on the committee, this committee next year as well.
All right, well, we're not actually technically on the bill, but I am going to go out of session to hear from your guest.
Thank you, Mr. Chairman.
Yes, sir. There's an on-off button there, and if you will press that, introduce yourself for the record. You'll have 3 minutes for comments.
Good morning. My name is LaShonda Salinas, and I live in Hartsville, Tennessee. Thank you for allowing me to speak. And I know this bill will not move this year, but I hope you will hear my story and we can do this again next year. I was convicted of criminal exposure to HIV in 2007. After my partner and I ended our relationship, he was angry and he filed a complaint stating I never told him I was HIV positive. I had no way of proving that I informed him, so therefore I was convicted of a Class C felony. I'm sorry. After 2 months in jail, on the advice of my public defender, I took a plea deal that resulted in a conviction and requirement to register as a sex offender. I have spent the last 17 years of my life on the sex offender registry. No Christmases, no Thanksgivings. Can't see my cousin walk across the stage. I'm sorry. I'm sorry, but this is my life. But I will tell you one thing. In 2023, thank you. In 2023, you all passed a bill that required the sex offender registration requirement from the criminal exposure law to be taken away. And as of July 7th, 2023, I was able to come off of the sex offender registry. While I am internally grateful for you all and to have my life back with my family that I haven't had in 17 years, I hate to say this, but I don't know my family. I don't know my little cousins that I want to be with. They don't know me. But I am grateful for the bill that you all did pass. Having a felony record limits my job opportunity, my housing, and not only that, my education. Being a convicted felon, I cannot go to college. I want to be a paralegal. I want to help with the laws. I do. But I can't because I'm a convicted felon. Advances in HIV treatment have made it possible to live with HIV. I've been positive for 25 years, and look at me. You will never know by looking at me that I'm HIV positive and been this way for 25 years. We can live a normal lifespan with the advance in medication. This law, it discourages people from getting tested. Because if you go get tested, you'll know everything, you will. But I don't want no one to live like me for 17 years. Do we have to do this? Can y'all just come into my shoes for just a little bit? Please. I want to be around my family. And I know there's other people that do too. And it's up to you all to give us that, please. I don't do a lot of begging, but I beg you all. When this bill comes back from Representative Thomas next year, will you all let me live my life? Thank you.
Thank you, ma'am. We'll go back into session. Representative Thompson.
Thank you, Mr. Chairman. Well, I won't be here next year, but I hope a bill to make some positive reforms on the current HIV law will be here. And it, the laws were set up a long time ago, and I've followed it all these last 40 years. And hopefully we will make some things that are more realistic and also more workable to help to protect the health of all Tennesseans. And with that, I will take my bill off of notice. And I thank you very much for the time you've given me.
Yes, sir. Thank you. And we'll be sure to do that for you at the end of this meeting. I'll take it off notice for you.
Thank you.
Yes, sir. Representative Chisholm. You've got item number 23. It was never calendared in the Senate, so the Senate never did take it up, but we're not going to be taking any action on it right now, but I'll give you a minute or so to talk about it, and then since you're here, we'll move on.
Thank you, Chairman and committee. On this bill, I'll be brief so we can save all of our time for a robust conversation over the summer and for going forward for next year. But what this bill does, essentially, it makes the offensive and criminal responsibility for conduct of another person. It keeps you from being charged with the same crime, just like with a murderer. If you were in the car with somebody who committed a murder, it keeps you from being charged with murder as well. But I want to thank you all for the future work that we're all going to do together in this subject matter. I look forward to all of the testimony that we'll have, and for all of you all help with perfecting this piece of legislation. So thank you so much. And with that, I will take this off notice.
All righty, sir. We'll handle that for you here shortly. Thank you. Members, that's all we've got right now on our regular calendar number 1. So without objection, all bills that were not taken up today will be taken off notice. And that will conclude the end of calendar number 1. We do have a second calendar. I don't know what date I'm on. Yes. All right, we're on final calendar number 2. All of these bills as well have either not been calendared or they have failed over in the Senate. Representative Pearson, you do have 7 bills here. If you would, I'd tell you what, just combine them all into one.
I can do it. It's an omnibus bill to end gun violence.
All right.
Thank you, Chairman, and do appreciate the opportunity to present on these bills, despite the action that's happened in the Senate. I really do appreciate that, and it is meaningful. Look, as all of you know, and many of the people here understand, we have a gun violence epidemic in our state, and we have a responsibility to do everything that we can to end this gun violence epidemic. Any child's life, any person's life that is being taken by this epidemic requires our full attention, awareness, and effort. And as people who are in positions of power in the ways that we can't just offer thoughts and prayers, or rather we shouldn't. We should offer action. And so the legislation that is on this slate here is to ensure that there are background checks for all firearms, including those that are mailed to individuals, because you can buy a 80% receiver of a weapon, which is not going to have which does not have to go through the same processes as if you go and get a firearm now. This legislation that I'm putting forward in this slate would ban high-capacity magazines and stop their continued existence and production in the state of Tennessee, and so that it would limit it to about 10. This legislation would have had for us to really study the effects of stolen guns. Since 2013, over 30,000 guns have been stolen in the state of Tennessee. That is something that we need to look at and learn. How did we get to such a place? Where the first year in 2013, about 46 guns were reported stolen. We're now up to about 5,247 a year. This is ridiculous numbers. And we know that our legislation and our efforts as a legislature can help to improve this situation. And one of the final things was really to study the impact of gun violence on our communities, and knowing that it does not fall on everyone equally. You turn on the news for Memphis and Shelby County, there is a crime that has been committed. There is someone who has lost their life accidentally through negligence or intentionally through violence that has happened. And we need to understand what those ramifications are and how we as legislators could use our positions and our power to take that information, to take the appropriate action. And so to all of my constituents, to all the people in the movement for justice rooted in love that is seeking to end the gun violence epidemic in our state by doing everything that you can, we will persist and we must continue to fight in the House side and the Senate side to pass legislation that helps us to end this epidemic, because it is possible. And so it is with that fervent hope, and not just prayer, but action, the fervent hope and work, that I believe we can pass legislation that will help to protect all of us in every community in this state. And it's for those reasons that I'm going to continue to bring forward this legislation into the next session. But I appreciate the opportunity to talk about it now. Thank you, Chairman.
Thank you very much. All right. Number 8 on the calendar failed in the Senate. It is sponsored by our own Representative Johnson. All right. All right, members. So items 1 through 8 on House final calendar number 2 will be returned to the clerk's desk. That completes that calendar. Members, I want to say this was our final calendar, and I'll recognize Chairman Halsey here in just a minute, but I want to say a special thank you to my legislative assistant, the lady that wears numerous hats and jackets for this committee, Miss Emily Hamby. Thank you so much for the work that you've done this year. Our research analyst, Mr. Ryan Baird, who does a fantastic job for this committee. I want to say thank you to him as well. Our attorneys, Michelle Fogarty and Alexandra Greenberg, for their help with us this year. Our clerk, Miss Laura Stewart, for her assistance in the criminal subcommittee. And our intern that came to us this year, Miss Rose Corres, to help be with us. It's been an honor to get to know you and wish you all the best as you move forward. Thank you for that. And last but not least, the one and only Sergeant of Arms, Mr. Tyler Muniz, who has stepped out and he's gone. So we're going to say thank you to Tyler. But Bobby is in his place. We got you. All right, Chairman Halsey.
Thank you, Mr. Chairman. And I have to say on behalf of the whole committee here, and I'm sure that they would all agree 100% that there's good folks down here, and then there's really qualified folks down here, and then there's top of the line people like the chairman of this subcommittee. And you have done a great job, and we appreciate you very much, your leadership. And so thank you.
Well, thank you. And I would like to sincerely say thank you to each and every member of this committee. We've done a lot of work this year. We've had some very tough and intense calendars, some long days and nights, and we've had some really heavy stuff that we've had to sort through this year. And I want to say thank you for your work on that. Representative Towns.
Yeah, Mr. Chairman, you made it look like a professional does, and it made it look like light work and handiwork because of your tack in the way you handle the members and handle the bills and allow everybody to have their say. And when you hear people talking, they talk about your fairness and how it is that they feel comfortable in the committee. And as you indicated, we've had some very sticky, pricky kinds of issues to come up. And one thing for sure about the committee, you champion, did not shy away from the work. I think one night we stayed at about 8:30, okay? And for that, you are to be commended for trying to do the best you can for the folk of the state of Tennessee. So I appreciate you.
Well, thank you for that. Representative Hardaway wanted me to inform everyone that he was buying lunch today, but he is out. He's had to step out. So he said Joe Towns was going to pick up the tab.
I figured that. That's the reason I brought my Citizen Robux card.
There you go.
I can handle it.
Members,
No
anything
problem.
else? Chairman Howe.
Chairman, thank you. And I just want to express what a pleasure it is to serve with you.
Absolutely.
You give this committee good guidance. Your even temperament and firm grip on the gavel has kept us going in the right direction. And we've done some good legislation under your guidance, and I appreciate you.
Well, thank you. Thank you for that. All right, ladies and gentlemen, the long-awaited motion is coming. We are going to be adjourned. Subject call to the chair. Thank you all.